ಬಯಟು ಆಫ್ ಸರ್ವಿಸ್ ಭಾರತದ ಯೋಗ ಪುಂಜಾರ चालू वाला
विषय सुंदर या सगळ्यांचे धन्यवाद। इसके बाद मैं विनती करना चाहता हूं अहमदनगर सेंट्रल एडवोकेट्स बार एसोसिएशन के हमारे प्रेसिडेंट एडवोकेट अशोक जी कोठारी की यहाँ आकर इस कार्यक्रम का प्रास्ताविक आप हमारे सामने प्रस्तुत है।
सेंट्रल एडवोकेट्स बार एसोसिएशन
ये चालू रहेगा, इसका कुछ प्रॉब्लम नहीं।
जिल्हा न्यायालय 200 वर्ष पूर्ण झाल्यानंतर या बार असोसिएशन एक व्याख्यानमाला आयोजित करण्याचा निर्णय घेतला। त्या व्याख्यानमालेची पहिली गोष्ट हे 6 एप्रिल 2025 रोजी माननीय जस्टिस रोहित साहेब आणि अनेक मान्यवरांच्या हस्ते या अहमदनगर शहरात बोललं गेलो। त्या कार्यक्रमासाठी सुद्धा सर्व न्यायाधीश मंडळी, वकील मंडळी यांनी योग्य आणि या कार्यक्रमाचे जे मुख्य अतिथी आहेत जस्टिस भुयान सुप्रीम कोर्ट ऑफ इंडिया यांच्या हस्ते बोललं झालं। निर्णय वकिलांना, न्यायाधीशांना, विद्यार्थ्यांना, वरिष्ठ लोकांचं मार्गदर्शन मिळावं या उद्देशानं मी हा व्याख्यानमालेचा प्रकल्प या ठिकाणी करत आलेलो आहे। तर आज या ठिकाणी उपस्थित असलेले या कार्यक्रमाचे प्रमुख अतिथी श्री भुयान साहेब, सौ भुयान आपल्या जिल्ह्याच्या पालक न्यायमूर्ती विभाजित अंतरवाडी, त्याचबरोबर आपल्या दुसरे पालक न्यायाधीश श्री जोशी साहेब, आमच्या जिल्ह्याच्या प्रधान जिल्हा न्यायाधीश शिंदे, त्याचबरोबर या ठिकाणी उपस्थित असलेले आमच्या जिल्ह्याचे DSP खंडे साहेब, त्याचबरोबर जिल्हा परिषदेचे CEO श्री कानन भंडारी, सर्व न्यायाधीश मंडळी, या ठिकाणी उपस्थित सर्वांचे मी सर्वप्रथम सेंट्रल ॲडव्होकेट बार असोसिएशनतर्फे सहर्ष सर, या ठिकाणी मी आपलं स्वागत करताना काही गोष्टी मांडू इच्छितो. अहमदनगर जिल्हा हा नुसता सहकारी साखर कारखानदाराची भूमी नसून ती एक दोन साधू संतांची भूमी आहे. या भूमीत संत ज्ञानेश्वर, साईबाबा, अहिल्यादेवी होळकर, मेहरबाबा, राष्ट्रसंत अमित जोशीजी महाराज आदी प्रवृत्तींना या जिल्ह्याचे नाव जगभर अग्रामोल केलेले आहे. त्या ऐतिहासिक संत भूमीत सर्वोच्च न्यायालयाचे न्यायमूर्ती माननीय श्री पूज्य श्री भुयान यांच्या सुविधेप्रती संघमित्रालय भुयान, जिल्ह्याचे पालक न्यायाधीश श्री विभाजित अंतरवाडी, प्रधान न्यायमूर्ती जोशी मॅडम, न्यायमूर्ती श्री जोशी साहेब, जिल्हा न्याय व्यवस्थेतील सगळ्यात महत्त्वाची गोष्ट की आपल्या न्याय व्यवस्थेला 200 वर्ष झालेली आहे. त्या 200 वर्षाच्या कारकिर्दीत पहिल्यांदाच आपल्याला या महिला जिल्हा प्रधान न्यायाधीश मिळालेले आहेत. मी आपल्याला विनंती करेन की या गोष्टीचं निदान नगर जिल्ह्यातून स्वागत करायचं. ती फर्स्ट वुमेन लेडी प्रिन्सिपल डिस्ट्रिक्ट. तर या कार्यक्रमासाठी आपण सर्वांचं या ठिकाणी स्वागत करतो. या कार्यक्रमाला आम्ही न्यायदान क्षेत्रात मौलिक कामगिरी बजावलेली व ज्यांनी आयुष्यातील 75 वर्षे गाठली अशा प्रतीचे श्रोतेला अन्य सर्व मान्यवरांना, जिल्ह्यातील न्याय व्यवस्थेतील सर्व जजेस जे आहेत त्यांचे आदर्शशील उपस्थिती हा हार्दिक स्वागत समारंभ करत आहे. जिल्हा न्यायालयाच्या संस्थेत 200 वर्षांच्या पूर्तीनिमित्त शानदार सोहळ्याच्या आयोजनाबरोबरच निरनिराळ्या क्षेत्रातील मान्यवरांचे उद्बोधपर व्याख्यानांचे पुष्प कुंभण्याचे सेंट्रल कार्यक्रमासाठी जस्टिस अभय यांनी अतिशय मौलिक मार्गदर्शन पहिल्यापासून ज्यावेळेला त्यांनी पहिलं पुस्तक या ठिकाणी बोललं त्यावेळेला त्यांनी दिलेलं होतं आणि ते मार्गदर्शन त्यानंतर बऱ्याचशा लोकांनी त्याच्यावर निघालेल्या पुस्तकाची चर्चाही केली आणि अतिशय मोठं मार्गदर्शन म्हणून त्यांचा या ठिकाणी कार्यक्रमासाठी सर्वोच्च न्यायालयाचे न्यायमूर्ती श्री हे आलेले आहेत. त्यांचा थोडक्यात परिचय मी या ठिकाणी करून देणार किंवा माझं करते. गुवाहाटी येथे एका न्यायिक क्षेत्रात समर्पण असलेल्या कुटुंबात आलेला होता. किशोरी कॉलेज दिल्ली येथून पदवी, गुवाहाटी विद्यालयातून केलेली व LLB पदवी मिळवली. आसाम, नागालँड, मेघालय, मणिपूर, त्रिपुरा, मिझोराम, अरुणाचल प्रदेश येथे यशस्वी वकील केली. गुवाहाटीत असताना त्यांनी आपल्या कामकाजातून उभारलेला होता. मेघालय सरकारचे वकील, आसाम राज्याचे माजी सरकार, गुवाहाटी उच्च न्यायालयाचे, मुंबई उच्च न्यायालयाचे हे न्यायमूर्ती, तेलंगणा उच्च न्यायालयाचे उच्च न्यायमूर्ती म्हणून त्यांनी काम केलेलं आहे. त्यांचे निवाडे आजही रेफरन्स म्हणून नेहमीच दर्शवले जातात आणि त्यांची जर स्टेटमेंट वाचली तर ती सखोल ज्ञानानं अशी इतकं भरलेली असतं असं निश्चितपणे आपल्या निदर्शनास येईल. 5 जुलै 2023 पासून सर्वोच्च न्यायालयाचे न्यायमूर्ती या नात्याने कामकाजाचा ठसा हे आजपर्यंत उमटत आलेले आहेत व आजही ते मुंबई दिल्ली उच्च न्यायालयाचे न्यायमूर्ती म्हणून या ठिकाणी कामकाज करणार आहेत. आपल्याला या ठिकाणी निदर्शनास आजच्या या सोहळ्यात मुंबई उच्च न्यायालयाचे आपले पालक न्यायमूर्ती श्रीमती भुयान त्यांच्यामुळे या सोहळ्यात या कार्यक्रमात शोभा द्विगुणित झालेली आहे. न्यायदान क्षेत्रातील त्यांचे आगळेवेगळे स्थान राहिलेले आहे. कर्नाटक विजापूर येथे त्यांचा 1964 साली जन्म झालेला आहे. नांदेड येथे पदवी घेतलेली आहे त्यांनी. सातारा येथे LLM कोल्हापूरच्या शिवाजी विद्यापीठातून त्यांनी संपादन केले आहे. 1987 ते 1962 या काळात राज्यातील
हॅलो.
काम केले होते. 2002 साली जिल्हा परिषद न्यायाधीशांना प्रशिक्षित करण्याचे काम त्यांनी या ठिकाणी केले होते. निश्चित ही गोष्ट कौतुकास्पद आहे. मी आपल्याला सांगेन की दिस वर्क should be acknowledged by category. आपले दुसरे जातीय न्यायमूर्ती रोहित साहेब यांनी नागपूर विद्यापीठातून भारतरत्न डॉक्टर बाबासाहेब आंबेडकर लॉ कॉलेजमध्ये गेलेले होते. 1999 साली दिवाणी औद्योगिक व कामगार कायद्यात पारंगतता मिळवलेली आहे. पुणे, धुळे, नाशिक, ठाणे व अमरावती जिल्ह्यात त्यांनी सत्र न्यायाधीश कार्य केलेले आहे. 2024 पासून ते मुंबई उच्च न्यायालयाचे न्यायमूर्ती म्हणून या ठिकाणी आलेले आहेत. जिल्हा न्यायालयाच्या 200 वर्षाच्या इतिहासात मला म्हटल्याप्रमाणे आमच्या प्रधान जिल्हा न्यायाधीश शेंडे मॅडम यांचा आपण कौतुक केलेलं आहे. त्यांचंही मोठे मार्गदर्शन यांनी वकील वर्गात ठेवलेल्या होत्या. त्या सगळ्यांचा लेखक होता त्या अंतामध्ये आम्ही मांडलेला आहे आणि तो जो आमचा सवयीने राहिला म्हणून हे निश्चितपणे प्रत्येक लिगल सिस्टीम मध्ये काम करणाऱ्या मंडळींनी आपल्याला एकदा वाचून पाहिल्यानंतर तो संग्रहित ठेवावा अशी त्यांना निश्चितपणे वाटत. असे न्यायमूर्ती प्रकाशन सुद्धा आम्ही त्या ठिकाणी केले. ग्रंथामध्ये ऐतिहासिक दस्तऐवज म्हणून प्रेरणादायक ठरतात. या स्मृती ग्रंथाचे संपादनासाठी मला त्यांनी त्यांचा रेफरन्स दिला नाही तर ते चूक होईल. आमच्या माझे सहकारी श्री अशोक पुरापती यांनी तो ग्रंथ लिहिण्याकरता अतिशय गुणाचं मार्गदर्शन सहकार्य केलं. लॉ लायब्ररीमध्ये जाऊन वेगवेगळ्या ठिकाणी जाऊन वेगवेगळे संदर्भ त्यांनी गोळा केले, वेगवेगळी माहिती गोळा केली आणि याप्रमाणे आम्ही तो स्मृतिबद्ध जो काय मंदिर आहे तो या ठिकाणी आपल्याला सादर करतो. मी पुन्हा एकदा जाहीर व कृतज्ञ पुरस्कारांचा उल्लेख या ठिकाणी करतो. जिज्ञासू वाचकांनी या स्मृतिग्रंथाचे विविध प्रतिक्रियाद्वारे स्थापित केलेले आहे. न्यायालयीन स्तरावरही त्याची नोंद चांगली म्हणून देण्यात आलेली आहे. इतर जिल्हा न्यायालयाच्या शताब्दी नोंदवासाठी या ग्रंथाची मागणी होत असून त्यांचाही मार्गदर्शक पथदर्शी ठरत आहे. त्याचा उल्लेख करताना मला या ठिकाणी निश्चितपणे आनंद होत आहे आणि मी या कामाचा श्रेय आमच्या भारताच्या सर्व सदस्यांना आणि न्यायाधीशांना या ठिकाणी देण्याचं हे माझं कर्तव्य आहे. अशा विविध वैशिष्ट्यपूर्ण कार्यक्रमाच्या आयोजनात आपल्या सर्वांची उपस्थिती वडामोठ्यांचे मार्गदर्शन हे प्रेरणादायी ठरत आहे. आज 75 वर्ष पूर्ण केलेल्या ज्येष्ठ वकिलांचा आम्ही या ठिकाणी सत्कार समारंभ आयोजित केलेला आहे. त्यांचे फेलिसिटेशन त्या ठिकाणी आम्ही करणार आहोत. एक आगळा वेगळा काढला आम्ही अहमदनगर जिल्ह्याच्या इतिहासात एक नवीन त्या ठिकाणी निर्माण करत आहोत. तोही कार्यक्रम आपल्याकडे निश्चित थोड्या वेळातच आपल्याला पाहायला मिळेल. आजच्या व्याख्यानामध्ये कार्यक्रमातून मिळणाऱ्या समृद्ध ज्ञानाचा अनुभवाचा नवीन पिढीला प्रेरणा मिळून न्याय सर्वांसाठी या तत्वानुसार न्यायकांवरती केला त्याची मिळेल असा दृढ विश्वास या ठिकाणी व्यक्त. या सोहळ्याच्या यशस्वी करता माझे सर्व सहकारी समितीचे सदस्य पदाधिकारी सभासदांच्या समिती सदस्यांचे बळ प्रत्यक्ष कृतीला बळ देत आहे. त्या सर्वांच्या ऋणात राहण्याची पसंत करतो. या सर्व प्रक्रियेतून सर्व घटकांचा आपण जिज्ञासू व ज्ञानाच्या सहभागीमध्ये उपस्थितांच्या ही तुम्ही आहे. परंतु या पुनश्च एक वार आत्मा सर्वांचे मनपूर्वक स्वागत करून मी आत्मा सर्वांचे या ठिकाणी आभार मानतो. व आपल्याला आज भुयान साहेबांचे लेक्चर आहे ते लवकर आणि बराच वेळ आपल्याला त्यांचं मार्गदर्शन लागणार आहे. तर त्यांनाही आपण भरपूर वेळ या ठिकाणी देणार आहोत. या कार्यक्रमासाठी मला विशेष मदत झाली ती म्हणजे आमच्या कार्यकारिणीचे ज्येष्ठ सदस्य ॲडव्होकेट आटेवाडी, ॲडव्होकेट भापकर, ॲडव्होकेट देशपांडे, ॲडव्होकेट काके या सर्वांचं सहकार्य, त्याचबरोबर सर्व बातमीदार माझ्या सर्व कमिटी सदस्यांचं या ठिकाणी निश्चितपणे त्या ठिकाणी निर्देश करा. हा कार्यक्रम घेण्यासाठी आम्हाला ज्यांनी मदत केली ते आमचे जुने स्नेही जोशी साहेब, त्याचबरोबर किशोर पाटील आणि आमचे जावई यांना या ठिकाणी विशेष त्यांचे अभिनंदन करतो. या कार्यक्रमासाठी आपण सर्व उपस्थित झालेला आहात आणि वेगळा कार्यक्रम आम्ही आपल्यासमोर सादर करण्यासाठी सर्वांना केलेला आहे. सर्वांचं शेकवा मी स्वागत करून विनंती करू शकतो.
धन्यवाद सर. आज या कार्यक्रमासाठी इथे मंचावर उपस्थित असलेल्या सर्व सन्माननीय अतिथींचा आता आपण सन्मान करणार आहोत. हे आपलं सौभाग्य आहे की इतकी मोठी माणसं सातत्यानं आपल्यामध्ये जे उपस्थित होतात आणि आपल्याला त्यांचे विचार ऐकता येतात, त्यांचं मार्गदर्शन आपल्याला मिळतं. इट्स अवर ऑनर. सबसे पहले मैं रिक्वेस्ट करूंगा एडवोकेट अशोक जी कोठारी, एडवोकेट वी अत्ते साहब, एडवोकेट जी भापकर, एडवोकेट के देशपांडे और एडवोकेट एस जे ठाकरे, इन सबको कि आप अपने शुभ हाथों से सम्माननीय न्यायमूर्ति उज्जवल जी भुयान सर, इनका हमारे शहर की ओर से और अपने एसोसिएशन की ओर से यहाँ पे स्वागत और सम्मान करें. I request all the members, senior members, please felicitate and welcome Honorable Judge Bhuyan sir. खरं तर त्यांची परिपूर्ण ओळख नुकतीच कोठारी साहेबांनी करून दिलेली आहे. पण गुजरातची भुयान सर हे मूळचे गुवाहाटीचे आहेत. त्यांचे वडील सुचेंद्रनाथ भुयान हे सुद्धा सिनियर ऍडव्होकेट आणि फॉर्मर ऍडव्होकेट जनरल ऑफ आसाम म्हणून कार्यरत होते. गेल्या अनेक वर्षांपासून गुजरातची भुयान सर आपल्या कर्तृत्वानं बुद्धिमत्तेनं आपल्या न्याय व्यवस्थेमध्ये स्वतःचे योगदान देत आहे, याचा आपल्याला निश्चित अभिमान है। इसके बाद मैं रिक्वेस्ट करूंगा एडवोकेट वारुण से आप मंच पर पधारे और अपने सुहातों से सौसंघमित्रा दास भुयान जी इनका भी यहाँ पे कोई व्यक्ति हमारा इतना ही बड़ा अतिथि है और उसका स्वागत और सम्मान करना ये हमारा कर्तव्य है। मैं मैडम से रिक्वेस्ट करता हूं कि आप प्लीज आगे आइए। Now I request Advocate Sue Vijaya Subhash Kakre कि आप मंच पर पधारे और ऑनरेबल विभाजी अंकलवाड़ी मैडम इनका सम्मान करें। धन्यवाद। यानंतर विनंती करतो ऍडव्होकेट विश्वासराव पाटील यांना की आपण आपल्या सदस्य उच्च न्यायालय मुंबईचे माननीय न्यायमूर्ती श्री रोहितजी जोशी यांचा सन्मान करावा। यानंतर विनंती करतो ऍडव्होकेट सौ वैशाली हेमंत कराळे यांना की आपण मंचावर यावं आणि आपल्या शुभहस्ते आपल्या अहिल्यानगर जिल्ह्याच्या प्रधान जिल्हा न्यायाधीश श्रीमती अंजू शेंडे मॅडम यांचा सन्मान करावा। यानंतर विनंती करतो ऍडव्होकेट जयवंत भास्कर यांना की आपण आपल्या शुभहस्ते जिल्हा पोलीस अधीक्षक सन्माननीय सोमनाथजी भगेसर यांचा सन्मान करायचा आहे। मी विनंती करतो साहेबांना की प्लीज आपण मंचावर यावं। धन्यवाद सर। यानंतर आपण आपल्या या न्यायदान क्षेत्रात मौलिक योगदान देणाऱ्या आणि ज्यांनी गेली अनेक वर्ष आपल्या या कोर्टामध्ये आपली सेवा दिलेली आहे अशा ज्येष्ठ वकील बांधवांचा, न्यायमूर्तींचा सम्मान करणार आहोत। सर, आज इस मौके पर हमने एक बहुत अलग कंसेप्ट यहाँ पे रखी है जो बहुत सालों से हमारे इस कोर्ट में वर्किंग कर रहे हैं। ऐसे हमारे सारे जो सीनियर मेंबर्स हैं इनका हम फेलिसिटेशन करने जा रहे हैं और हमारा सौभाग्य है कि ये फेलिसिटेशन आप जैसे मान्यवर अतिथि के उपस्थिति में और आपके शुभारंभों से होने जा रहा है। वी आर वेरी प्लीज्ड टू हैव यू हियर सर। आपल्यामध्ये नुकतेच अहिल्यानगर जिल्हा परिषदेचे मुख्य कार्यकारी अधिकारी सन्माननीय श्री आनंदजी भंडारे साहेब यांचं आगमन झालंय। त्यांचा मी मनापासून स्वागत करतो आणि त्यांना विनंती करतो की आपण मंचावर यावं। ऍडव्होकेट किशोरजी देशपांडे यांना विनंती करतो की आपण आपल्या शुभस्ते सन्माननीय श्री आनंदजी भंडारे यांचा सन्मान करावा। मनापासून धन्यवाद। यानंतर आपण आपल्या सन्माननीय बांधवांचा इथे सन्मान करणार आहोत। ऑल द सिनियर मेंबर्स, सगळ्यात पहिल्यांदा आपण सन्मानित करणार आहोत ऍडव्होकेट प्रमोदजी जोशी। अहमदनगर जिल्ह्यातील राहत्याचे रहिवासी असणारे आणि मुंबई उच्च न्यायालयातील प्रसिद्ध वकील दुधाट यांच्याकडे ज्युनियरशिप त्यांनी सुरुवातीच्या काळात केली। दिवाणी आणि फौजदारी अपिलाचे कामकाज ते मुंबई येथील उच्च न्यायालयात यशस्वीपणे करत होते। आजही निरनिराळ्या सामाजिक संस्थांमध्ये त्यांचा सहभाग असतो आणि आज त्यांचे काही ज्युनियर्स उच्च न्यायालयाचे न्यायमूर्ती झालेले आहेत। आय रिक्वेस्ट ऑनरेबल कुंजनजी भुयान सर, प्लीज फेलिसिटेट ऑनरेबल ऍडव्होकेट प्रमोदजी जोशी सर। सरकारचं सांगितले तुम्ही तयारच ठेवा। मी माहिती सांगायला लागल्यामुळे तुम्ही घेऊन मंचावर या। यानंतर आपण सन्मानित करणार आहोत सन्माननीय ऍडव्होकेट नितीनजी गवारे यांना। अहमदनगर जिल्ह्यातील कर्जत तालुक्यातील एका शेतकरी कुटुंबात हे सुपुत्र औरंगाबाद खंडपीठात वकिली व्यवसायासाठी प्रारंभ केला। दिवाणी आणि फौजदारीच्या अनेक अपिलांमध्ये आपल्या वक्तृत्व शैलीमुळे आणि कायद्याचा गाढा अभ्यास असल्याने आपल्या नावाचा ठसा उमटवला। सध्या मुंबई येथील उच्च न्यायालयात ते आपला वकील व्यवसाय करतात आणि अनेक नवीन ज्युनियर वकिलांना ते मार्गदर्शनही करत आहेत। ऍडव्होकेट नितीनजी गवारे। सरकारचं साहित्य तुम्ही तयार ठेवा आणि एक जणाला वरती पाठवून ठेवा म्हणजे आपली गडबड होणार नाही। यानंतर आपण सन्मानित करणार आहोत ऍडव्होकेट किशोरजी पाटील यांना। किशोरजी पाटील हे मुंबई उच्च न्यायालयात आपला व्यवसाय सध्या करतात। उच्च न्यायालयातील न्यायमूर्ती दुधाट साहेब यांच्याकडे त्यांनी सुरुवातीच्या काळात ज्युनियरशिप केली आणि मुंबई उच्च न्यायालयात वयोमुक्त वकील म्हणून त्यांची विशेष ख्याती आहे। सर, आपलं मनपूर्वक अभिनंदन। यानंतर आपण काही तरुणांचा सन्मान करणार आहोत। तरुणांचा याच्यासाठी म्हणतोय की त्यांनी आता अवघी आपल्या वयाची 75 वर्ष पूर्ण केलेली आहेत आणि दे आर स्टील वर्किंग। सो वी आर व्हेरी हॅपी टू ऑनर यू, फेलिसिटेट यू। सगळ्यात पहिल्यांदा मी मंचावर आमंत्रित करतो ऍडव्होकेट अच्युतराव चौधरी यांना। शहरातील एक अत्यंत नामवंत आणि निष्णात असे फौजदारी वकील, अनेक निरनिराळे सेशन खटले त्यांनी चालवलेले आहेत। अहमदनगरमध्ये रिमांड हो आणि बाबावाडी या सामाजिक संस्थेत ते कार्यरत आहेत. बॅकग्राऊंड म्युझिक बंद केलं तरी चालेल, कारण आम्हाला एकदा टाळ्या ऐकायच्या. या तरुणांसाठी आपण टाळ्या वाजवल्या पाहिजे. 1972 मध्ये नगरच्या दिवाणी आणि फौजदारी न्यायालयात त्यांनी वकिलीची सुरुवात केली. अहमदनगर मर्चंट बँकेच्या संचालकपदी निवडून आले. नगर अर्बन कोऑपरेटिव्ह बँकेचे चेअरमन म्हणून सुद्धा त्यांनी यशस्वी कारकीर्द आपली बजावली. बँकिंग क्षेत्रात उत्कृष्ट कामगिरी करून महाराष्ट्र बँक फेडरेशनचे संचालक होण्याचा सुद्धा त्यांना बहुमान मिळाला. अनेक इन्शुरन्स कंपनीच्या पॅनलवर सिनियर पॅनल ऍडव्होकेट म्हणून त्यांनी काम पाहिले आणि वकिलांसाठी ऍडव्होकेट चेंबर बिल्डिंग उभारण्यात सिंहाचा वाटा जर कोणाचा असेल तर तो कोठारी साहेबांचा आहे. घरातला एक मोठा वारसा त्यांना सामाजिक सेवेचा आहे. त्यांचे वडील अनेक वर्ष भारतीय राष्ट्रीय काँग्रेसमध्ये कार्यरत होते आणि नगर जिल्ह्यातील एक अग्रणी व्यक्ती म्हणून प्रसिद्ध होते. यानंतर आपण सन्मानित करणार आहोत ऍडव्होकेट ए उगळे साहेब यांना. दिवाणी कायद्यातील सखोल अभ्यास असलेले हे नामवंत वकील. मुंबई उच्च न्यायालयाचे औरंगाबाद खंडपीठ इथे त्यांनी अनेक खटल्यामध्ये आपलं काम पाहिलेलं आहे. माननीय ए उगळे साहेब. यानंतर आपण सन्मानित करणार आहोत सन्माननीय ऍडव्होकेट विश्वासरावजी पाटील यांना. आता आपण सन्मानित करतो आहोत ऍडव्होकेट ए उगळे साहेब यांना आणि आता आपण सन्मानित करणार आहोत ऍडव्होकेट विश्वासराव पाटील. अतिशय संपन्न अशा कुटुंबाचा वारसा घेऊन आठवे साहेबांनी या क्षेत्रात आपल्या कामाला सुरुवात केली. जिल्हा सरकारी वकील, बार काउन्सिल ऑफ महाराष्ट्र आणि गोवाचे चेअरमन अशा अनेक जागांवर त्यांनी आपली सेवा दिली. सध्या ते अहिल्यानगर जिल्ह्यातील सगळ्यात मोठ्या अहमदनगर जिल्हा मराठा विद्या प्रसारक समाज संस्थेचे सचिव म्हणून कार्यरत आहेत. एक अत्यंत रसिक आणि गुणग्राही व्यक्ती म्हणून त्यांचा नावलौकिक आहे. यानंतर आपण सन्मानित करणार आहोत सन्माननीय ऍडव्होकेट अच्युतराव पिंगळे यांना. अहिल्यानगर शहरात वकिली व्यवसाय त्यांनी सुरू केला. सामाजिक कामात ते कायम अग्रणी असतात. गेली अनेक वर्ष गीता पठणाचा उपक्रम ते घेतात. नगर अर्बन बँकेच्या ठेवीदारांना न्याय मिळवून देण्यासाठी लढणारे एक मुख्य सेनापती म्हणून सुद्धा त्यांचा नावलौकिक आहे. आणि नगर शहरात ऋग्वेद भुवन ही एक इमारत त्यांनी समाजातल्या लोकांसाठी एक हाती बांधली. त्यासाठी अत्यंत मोठा असा निधी त्यांनी उपलब्ध केला. माननीय पिंगळे साहेब. यानंतर आपण सन्मानित करणार आहोत ऍडव्होकेट पीटी मनोज साहेब यांना. ते आज आपल्यामध्ये उपस्थित नाहीत, पण एकदा आपण त्यांच्यासाठी जोरदार टाळ्या वाजवूया. यानंतर आपण सन्मानित करतो आहोत ऍडव्होकेट एस गांधी यांना. मी विनंती करतो गांधी साहेबांना की आपण मंचावर यावं. अहमदनगर शहरात सुरुवातीला दिवाणी कामकाजाला त्यांनी सुरुवात केली. त्यानंतर शहरामध्ये टॅक्स कन्सल्टंट म्हणून त्यांनी काम पाहिलं. त्याचप्रमाणे निरनिराळ्या सेल टॅक्स, जीएसटी, इन्कम टॅक्स ट्रिब्युनल मध्ये पण ते काम पाहतात. माननीय एस गांधी साहेब. नाउ आय रिक्वेस्ट आणि अजून एक महत्वाची म्हणजे मंचावर आपल्या बऱ्याच जणांचे ते टॅक्स कन्सल्टंट आहेत, त्यामुळे सगळ्यांचं आर्थिक नियोजन उत्तम आहे. Now we are going to felicitate and advocate I.B. काझी सर. इंग्रजी भाषेवर प्रभुत्व असणारे एक प्राध्यापक. कॉन्व्हेंट स्कूलमध्ये प्राध्यापक म्हणून त्यांनी काम केलं आणि निवृत्तीनंतर वकिली व्यवसाय सुरू केला. इंग्लिश ड्राफ्टिंग मध्ये ते अत्यंत निष्णात आहेत. सो आय एम लिटिल बिट नर्वस टॉकिंग इन फ्रंट ऑफ देम इन इंग्लिश. सर प्लीज एक्सक्यूज मी इफ आय मेक एनी मिस्टेक. यानंतर आपण सन्मानित करणार आहोत ऍडव्होकेट जगदीशजी खंडेलवाल साहेब यांना. अहमदनगर कोर्टामध्ये मिनिस्ट्री ऑफ डिफेन्स या कामात त्यांनी प्रावीण्य मिळवलं आणि निरनिराळ्या कोर्टांमध्ये कोर्ट मार्शलच्या चौकशी कामात सुद्धा ते सहभागी झाले. ॲडव्होकेट जगदीशजी एंडेव्हर.
सुन ना अरे बेटा अपने फोटो लेना लाइव चालू उससे आगे का ये भेजन पूरा चल लाइव तो बोल आज सर के लिए लिया ना सर का वो तरी को बाद में
यानंतर आपण सन्मानित करणार आहोत ॲडव्होकेट एच.एस. काकाणी यांना. सगळ्यात ज्येष्ठ वकील म्हणून ते आज आपल्याला सगळ्यांना माहिती आहे. सिव्हिल कामामध्ये त्यांचा मोठा खंडा होता. निरनिराळ्या मोठ्या आपल्या वेगवेगळी शैली उमटवणारे वकील आज ते प्रकृती अस्वास्थ्यामुळे आपल्यामध्ये उपस्थित नाहीत. त्यांच्या वतीनं त्यांचे चिरंजीव ॲडव्होकेट अरविंदजी काकाणी हा सन्मान स्वीकारत आहेत. एकदा जोरदार टाळ्या काकाणी साहेबांसाठी. यानंतर आपण सन्मानित करणार आहोत सन्माननीय ॲडव्होकेट अशोकजी सरकर साहेब यांना. अहमदनगर जिल्ह्यातील कर्जत जामखेड कोर्टात त्यांनी आपल्या व्यवसायाला प्रारंभ केला. निरनिराळ्या बँकांच्या पॅनलवर ते कायदेशीर सल्लागार म्हणून कार्यरत होते. आज वयाची 75 त्यांनी पूर्ण केलेली आहे, पण तरीही अनेक जण आज त्यांचं मार्गदर्शन घेण्यासाठी त्यांच्याकडे जात असतात. ते त्यांना मनमोकळेपणानं मार्गदर्शन करत असतात. ग्रामीण भागातून येऊन सुद्धा आपल्या बुद्धिमत्तेनं या वकिली व्यवसायात स्वतःची वेगळी ओळख निर्माण करणारे ॲडव्होकेट अशोकजी सरकर साहेब. एक छोटीशी विनंती करतो, आपण ज्या सर्व ज्येष्ठ वकील बांधवांचा सन्मान केला त्यांनी 1-2 मिनिटं फक्त मंचाच्या समोर जर आपण येऊन उभे राहिला तर आपल्या सगळ्यांचा एकत्रित फोटो आम्हाला घेता येईल. पुन्हा मी सगळ्यांना पायऱ्या चढून वरती बोलवण्याची चूक करणार नाही. आणि आता या सगळ्यांसाठी आपण एकत्रित जोरदार टाळ्या वाजवणार आहोत. जोशी सर प्लीज प्लीज दबारे सर, जोशी सर, पाटील सर, आय रिक्वेस्ट फॉर टू ऑल्सो. या क्षेत्रात नव्यानं जी सगळी मंडळी आता कार्यरत आहेत किंवा येऊ इच्छित आहेत, आपल्या न्यायाधीश अंजुली शेंडे मॅडम यांना की आपण या कार्यक्रमाच्या निमित्तानं आपलं मनोगत इथे व्यक्त करावं.
अहमदनगर जिल्हा न्यायाधीश पुष्प गुंफारी आज आपल्याकडे मंचावर उपस्थित असलेले उच्च न्यायालय सर्वोच्च न्यायालयाचे न्यायाधीश माननीय उज्ज्वलजी भुयान व त्यांच्या पत्नी श्रीमती भुयान, आमच्या जिल्ह्याच्या फॉरेन न्यायमूर्ती तसेच उच्च न्यायालय मुंबई खंडपीठ औरंगाबाद येथील न्यायमूर्ती श्रीमती विभा कंटनगाळे, उच्च न्यायालयाचे न्यायाधीश आणि पालक न्यायमूर्ती श्री रोहितजी जोशी, या जिल्ह्याचे शासकीय अभियंता श्री ॲडव्होकेट श्री पाटील, सर्व या बारचे सेकंड बार असोसिएशनचे अध्यक्ष श्री अशोकजी कोठारे, तसेच सर्व मंचावर उपस्थित सन्माननीय विधिज्ञ, माझ्या समोर उपस्थित सर्व न्यायिक अधिकारी, सर्व विधिज्ञ मंडळ व इतर बंधू आणि भगिनींनो, खरं तर आजचा हा कार्यक्रम एक न्याय क्षेत्राशी जोडलेल्या लोकांसाठी एक पर्वणी आहे. आमचे न्यायाधीश मंडळी जे जिल्हा न्यायालयात कार्यरत असतात त्यांना अशी संधी फार क्वचितच उपलब्ध होते आणि माननीय उज्ज्वलजी भुयान दिल्लीहून इथपर्यंत आलेले आहेत. ते आम्हाला काय काय क्षेत्रात त्यांना जो आजचा या पुष्पमालेचा विषय आहे ते विषयाला धरून भारतातली जी काही संविधानिक स्थिती आहे आणि त्याचा जो काही परिणाम आहे त्याबद्दल ते आपल्याला भाष्य करणार आहे. खरं तर असे कार्यक्रम आणि असे प्रसंग जर आले तर लोकशाहीचे मजबूतीकरण हा जो विषय आहे सर्वसामान्य पर्यंत पोहोचण्यास मदत होते. स्ट्रेंथनिंग ऑफ डेमोक्रेसी म्हणजे डेमोक्रेटिक इंडिया आणि कॉन्स्टिट्युशनल डेमोक्रेसी आपल्याला सगळ्यांना ज्ञात आहे, परंतु त्याचं मजबूतीकरण हे सर्वसामान्यपणे कायद्याने करायचं, नागरिकांनी करायचं हे आपल्या कायद्याच्या अंमलबजावणी करणाऱ्या जे काही संस्था आहेत त्यांनी करायचं. हे अनेक प्रश्न अनेकदा निर्माण होत असतात. सर्वोच्च न्यायालय हे न्यायाच्या दृष्टीने न्याय देणारे सर्वोच्च न्यायपीठ असल्यामुळे न्यायाचा खरा अर्थ काय आहे आपण हे त्यांच्याकडून शिकत असतो आणि यालाच अर्थात दृष्टी आपल्याला उच्च न्यायालयाकडून मिळत असते. तर आजच्या या प्रसंगी अहमदनगर सेंट्रल बार असोसिएशनने हा कार्यक्रम आयोजित केला आणि त्यामुळे आम्हाला ही संधी प्राप्त झाली. त्यासोबतच मी असं म्हणेन की वकील वर्गांना सुद्धा, कारण न्यायाधीश मुळातच वकील आहे आणि वकिलीतूनच आलेले सगळे न्यायाधीश आहेत, तर वकिलांना सुद्धा ह्या सगळ्या संकल्पना सखोल आणि योग्य प्रकारे माहिती असणे गरजेचे आहे. विशेषतः किंवा असे काही व्याख्यानमालेत सहभागी व्हायला माझ्या कायद्याच्या ज्ञानात जो भर पडणार आहे तसंच माझ्या न्यायाधीशांना सगळं वकील वर्गाला पडणार आहे. सर्वांनाच न्यायिक बाजूनी माहिती असणे गरजेचं आहे. इथे बसलेले काही लॉ कॉलेजचे विद्यार्थी आहेत त्यांना सुद्धा मुळापासूनच ही गोष्ट माहित असणं अपेक्षित आहे. मी अपेक्षा अशी करते की ह्या सगळ्या कार्यक्रमामधून आज जो काही आयोजित झालेला कार्यक्रम आहे ह्याच्यातून जे नेणारे आमचे विचार आम्ही जे नेणार आहोत त्या विचारांचा प्रभाव आमच्या दैनंदिन दैनंदिन कामांमध्ये आणि तसंच आपल्या हातून होणारे निर्णय किंवा आपल्याकडून होणारे पक्षकारांची पैरवी यांच्यावर त्यांचा परिणाम होणार असेल. I would request all of you to just understand what Lordship is going to explain us. What is given in the Constitution and what is required in the democracy. Probably we are not able to interpret it in the proper sense or in the exact sense for which the provisions are made. We still keep on interpreting the provisions of law. It's not only we working in the district judiciary but also the high courts and the supreme courts. Because the transformation of the society changes the interpretation. There are judgments where it has been elaborated that whatever the previous interpretations were there, those were fitting to that situation of the society. The contemporary interpretations are must, and those are to be reviewed and revised and revisited. So for that, democracy, I think, what is the democracy which we were knowing is that liberty to expression, liberty to and exercising the rights, fundamental rights. But now the directive principles have also come into picture. So whatever is there in the Constitution, it is going to be implemented, and the implementation is, of course, from the side of lawyers. Lawyers may be as judge at the boardroom or practicing in any court. So I would request everyone to please take this opportunity as a rare opportunity to grasp and grab this knowledge going to be shared with us from the dais. I thank Ahmednagar Central Bar Association for inviting me and for making me to participate in this program along with my all judicial officers. I thank all those who have taken efforts for organizing this function, and I also take this opportunity to thank Justice Bhuyan, who is going to address us, and that is going to assist us in our day-to-day work. Thank you. Thank you very much.
Thank you, madam. Now I request Honorable Justice Rohit Joshi sir, please share your thoughts with us.
Honorable Justice Bhuyan, Judge, Supreme Court of India, Honorable Mr. Bhuyan, my elder sister, Justice Judge Bombay High Court, the Principal District and Session Judge of Ahmednagar District, Madam Anju Shinde, judicial officers, dignitaries, armed matters, and special mention to the young brigade of lawyers sitting before. As I stand today before you, let me tell you that after elevation as a judge of the Bombay High Court, I was from tomorrow onwards, my headquarters is shifted to Nagpur. So probably this is the last time that I am interacting with you as a candidate. I have two things to say about the judicial officers and the advocate food. Till recently I was an advocate. Contrary to what was said about me, till 24th of October 2025, I was a practicing advocate at Nagpur, and then elevated as an additional judge of the Bombay. Transformation from an advocate to judge taught me one thing, that something that I lacked probably while I was in practice. To sit for hours together on the dais and to listen to submissions made from the bar. It is not that easy as we perceive from the bar. To have long hours of concentration. As of now, I feel that it is sorry to say, at times a little boring. As an advocate, the first duty that you owe to the judge, also to your client, because ultimately you are to get all the relief from the client or from the judgment, is to keep the judge engrossed. Your submissions should be brief and to the point. From my personal experience of 10 months now, I mean a short experience of 10 years, 10 months and so. If the submissions go morose, then the judge, you are most likely to lose the grip of the matter. The judge is not going to be with you. And why? So the first act of advocacy is to be to the point, precise, and keep the judge engrossed. If possible, also entertain. Try to make him understand that there is something more than you are going to add to his knowledge as a student of law. That is the first advice that I want to give to advocates. Long arguments may give you some sense of satisfaction that you have argued your plea for such a long period. But that is not what pays. What pays is building the date for your life. There is one more thing that you should understand. With almost 100 or more matters on the board, it is but normal and natural that the judge will get impatient. So, to continue with your submissions and to keep the judge engrossed, you must be well read also. The judge should not feel for a moment that now the advocate is going beyond what is required for adjudication of the case. As a young lawyer, I am a first generation lawyer. The practice started growing with passage of time. When I started my practice, I spent as a redress or a lawyer with very few views. There is one thing that my senior told me, and my senior was also a first generation lawyer, and was climbing the ranks through a hard struggle. He was a salesman during his college days. He told me one thing, and that I have always kept in mind. My junior friends of the bar were present here, it is for them. There will be times when you will not have these to work on. Don't leave your office and sit in the office Let people at least know that there is an advocate here sitting in his chambers from at least 6 to 9:30 after the court. The phrase that my senior used and he advised me, I want to share it with you. And this is what his employer during the college days told me. गल्ला गरम रहे ना रहे, गादी गरम रहनी ही चाहिए. And that is the message that people don't know how much work you have. People don't know what you are earning. People will only know for how long you sit in the office, your office, what are your office timings, and how committed or dedicated you are. Being a lawyer without briefs also helped me immensely because I had hardly briefs to work on. The only thing that I had to do in the chamber was to go through the journals. These formative years, if you spend time in the office, 3 to 4 years, initial 4 years, can make your life as a lawyer, maybe as judge or whatever future prospects you foresee for yourself. So, earliest request to all the advocates to spend some time in the office. गादी गरम रहनी ही चाहिए. For the, let me tell you one thing more from my experience and from the way I was doing my practices. I was a very bad user. And if I felt that I had a point and I could not convince the judge, the fault always used to be with the judge, not with me. One such incident, when I came out of the court hall, angry because I could not win the day for one day. There was a senior advocate standing just outside the courtroom. He was the first person available to whom I could vent out my feelings. And I told him, sir, I had such a wonderful case, but the judge did not understand. Now he said, Rohit, he had 50 to 60 matters on his board. He is a judge for last 5 years. 210 working days. Every day attends at least 15 to 20 meaningful matters. Leave aside the other matters which are not that meaningful. And there are, in 20 matters, at least 40 advocates who are telling him something. And when they are telling him something, they prepare themselves to the best of their ability and then go and present it to him. In a sense, they are teaching him the law. So he is learning law from 40 teachers for 5 continuous years. That is not to say that what I want to emphasize is the bar should be considered as a teacher by the judge when he listens to the cases. This is what I have been doing. As a lawyer also, because my senior was practicing only in the High Court, I have practiced in the District Court as well. So I have learned from the bar. Just as that the bar should be treated as teacher when we hear cases, we should also identify between a good teacher and a bad teacher. And especially a teacher who teaches you what not to do. The faculties of ear, eyes, mind and then mouth is what a senior judge told me when I was elevated and former judge of the Bombay High Court when I went to take serious cases. He said those faculties of ear, eyes, brain and lastly faculties of your mouth, speech. So that is what I wanted to share with the judicial officers present in India. And lastly, I will be in the section of society as well, your present officers and advocates and judges. The topic on which the Honorable Judge of the Supreme Court is going to speak is a very interesting topic. When you hear it with this, this idea is at the back of your mind. We are a democratic republic. The government will be elected by a majority, but we are still a republic. Republic means a nation which is governed by the constitution. So, this is the subtle difference between majoritarianism and democracy. Thank you. And offering unsolicited advice probably is the biggest sin which I have committed to it. Please forgive me for that. Thank you.
Thank you, sir. Now I request Honorable Justice Vibha Kankanwadi Madam, please share your thoughts with us.
सर्वांना नमस्कार आणि गणेशोत्सवाच्या तसंच महालक्ष्मीच्या या उत्सवानिमित्त सगळ्यांना शुभेच्छा. बुद्धीची जी देवता आहे ती तुम्हा सगळ्यांच्या वरती आपला हात वरद हस्त तुम्हा सगळ्यांच्या वरती ठेवून ही इच्छा प्रकट करून ॲज अ गार्डियन जज ऑफ अहमदनगर डिस्ट्रिक्ट आय वेलकम Honorable Justice Shri Bhuyan, Srimati Anju Shende, Advocate Ashok Kothari, President, Ahmednagar Central Bar Association, other office bearers of the bar, the judicial officers of the district, senior and junior advocates attending this function, Deputy Superintendent of Police, Mr. Rohit, CEO Mr. Bhandari, DGP Shri Patil, senior members whose contribution to the legal field has been honored today, other dignitaries of the dais, and please forgive me if I have missed anybody's name. Cooperative movement was successful here. At present, there are around 120 judges working in the entire district. There is Sacred Family Court and other courts as well as tribunals. This district has maximum number of district, that is sessions divisions, and still there is demand from other bar associations also. We have problem of infrastructure and the staff, but every judge is putting his or her level best. On today's topic, I would like to say that democracy tries to put orders by establishing and enforcing the rule of law, ensuring the protection of rights, promoting accountability of government officials, and maintaining a balance of power among government branches. Courts, through their judgments and interpretations of the Constitution, can check the executive power, enforce social justice, protect fundamental rights, and ensure transparency in democratic process. Courts are the protectors of the rights guaranteed to the individuals by our Constitution. It is not that one has to approach High Court or Supreme Court only to protect his or her rights. In certain matters, the powers and jurisdiction is vested in the trial courts also. Take the example of provision under Section 91 of CRPC. It is equivalent to the writ of habeas corpus. All the facets would be explained by Honorable Lordship. I do not want to therefore transgress. In fact, and therefore I would like to stop here. I once again welcome Honorable Lordship, Madam Bhuyan, to my guardian district, and thankful to him for enlightening us on the topic. Thank you very much.
Thanks a lot, madam. आपने इस पूरे डिस्ट्रिक्ट की एक हिस्ट्री हम सबके सामने बहुत अच्छी तरीके से और संक्षिप्त रूप में रखी, और हमारे साथ आज जो यहाँ पे मौजूद है ऑनरेबल जज जी भुयान सर, इनको भी इसके बारे में, ऑनरेबल जस्टिस श्री भुजन जी भुयान सर, कि आप हमारे सामने यहाँ आकर हम सबको आपके आज के जो विषय है कोर्टाच्या माध्यमातून लोकशाही से मजबूतीकरण, ये जो सब्जेक्ट आपको यहाँ पे दिया गया है, इसके ऊपर अपना मार्गदर्शन हम सबको आप दें. Now I request Honorable Judge Bhuyan sir, please.
Thank you, Prasad. Ahmednagar Central Bar Association ने मला येथे बोलण्यासाठी आमंत्रित केल्याबद्दल मी खरोखर आभारी आहे. माझ्या सहकारी वकील मध्ये विशेषतः वर्चस्व तरुण सदस्य मध्ये असणे आहे आनंददायी आहे. Beyond this, I can't proceed. I would love to speak in your beloved language, but I have my limitations. So it's better to be safe than to commit some great mistakes. By the respected DGP of the state, the Superintendent of Police who is present here, the Chief Executive Officer of the Jilla Parishad who is present here, all the respected judicial officers with whom I had a brief interaction in the morning today, learned advocates, all the elderly advocates who are present here, members of the Oswal Samaj Sangh, learned advocates, members of the public, my friends from the media, and my dear students of law. A very good morning, good afternoon to all of you. Seeing all the elderly advocates and felicitating them myself took me back to many years ago, when the Bar Council of Assam, etc., had felicitated my father on completing 50 years of practice. I realized how difficult to sustain a legal practice of 50 years. It is no joke. And I always believe that the practice of law, the essence of the practice of law will not be understood in such time once you hold a brief for the petitioner or the plaintiff or the accused. You have to build a case brick by brick. Then only you understand what legal practice is. Friends, I am extremely delighted to be present here amidst you in this festive occasion, on the occasion of Ganesh Utsav, my heartiest best wishes to all of you. The beating of drums while felicitating the senior advocates reminded me of my Durga Puja days. All those balloons and festivities. So thank you for recreating that ambience of celebration. In fact, we are today celebrating the journey of our senior friends at the bar. It's wonderful feeling to hear. History tells us that the city of Ahmednagar, now we call it Ahmednagar, was founded in the year 1490 by Ahmed Nizam Shahi I, who made it the capital of Nizam Shahi dynasty. Ahmednagar fort was built during that time. Over the years, this fort has acquired great significance. During the freedom struggle, this is the place where a lot of activities have taken place, particularly during the Quit India movement of 1942. Our national leaders like Pandit Jawaharlal Nehru, Sardar Patel, Maulana Azad, Govind Bandhu. Nehru started writing his classic and iconic work, Discovery of India, in this Ahmednagar fort. So, it's a great honor and privilege for me and my wife to be here in this historic city. And as the learned principal district judge has said, Ahmednagar District Court was established in the year 1818, more than 200 years ago. Today, it has become one of the biggest judicial districts in the state of Maharashtra, having as many as 116 judicial officers with whom I had an interaction this morning. The Ahmednagar bar is a strong and a vibrant bar. It should remain united. Bar should always remain united because you represent the voice of the people. You should not have any individual agenda. You represent the problems and voice of the people. Over the years, Ahmednagar bar has produced very, very distinguished lawyers and judges who have made all of us very proud. Therefore, it is indeed a matter of great honor and privilege for me to come to Ahmednagar bar and to interact with my lawyer friends. Friends, I have a special affinity towards the legal fraternity. I myself was a lawyer. As I said, my father practiced for almost 60 years. He started as an article clerkship during those days, and we had the system of article clerkship. You had to intern, and at the end of with a senior, and at the end of the internship period, the full court of the High Court used to take an examination. If you pass that examination, then only the salon will be given to you, the license will be given to you, and then only you will practice. My father interned under Fakhruddin Adiyami, who was the then president of the Guwahati High Court Bar Association, and who later on became the finance minister of the state and went on to become the president of India in 1970s. Though he is remembered for perhaps many wrong reasons, but that's the difference. I practiced for more than 2 decades before I became a judge. My wife practiced for more than 17 years before she gave up practice on my elevation. That's again a very debatable issue whether the spouse should give up his or her practice on somebody's elevation. That's again a very highly debatable issue. My daughter, who is doing her PhD in law in Maharashtra National Law University in Mumbai, she had taken admission, she has taken license with the Bar Council in 2021. So this 3 generation of us, we put together, we have 100+ years of experience at the bar. So, I feel more comfortable in the company of lawyers. I said this, I have no hesitation in saying this. I said this in Hyderabad. I said this back home also. The lawyer in me, as Justice Rohit has said, refuses to die down. In fact, it is better to have the spirit of lawyer inside you that will challenge you in thinking and thinking and thinking. Because the moment you stop thinking, the creativity will stop and your ideas, the flow of ideas will dry up. Today morning I discussed, so I am not going to repeat what I said there about the trial courts. And in fact, it was Professor Upendra Bakshi who started a debate that trial courts should always be referred to as trial courts and not as lower courts or subordinate courts. I fully endorse this view, and we had put in practice when I was Chief Justice in Telangana by issuing notification that henceforth nobody should refer to the district courts as lower courts or subordinate courts. It should be referred to as trial courts or district courts. In fact, with Justice Oak and myself, we had delivered an order in a case called Sakhawat versus State of UP, where we said that henceforth it would be appropriate for the registry of the Supreme Court to refer to lower court records, not as lower court records, but as trial court records. Friends, you may be wondering why I am saying all this. I am saying all this with a purpose. Referring to trial courts or district courts as subordinate courts or lower courts affects the dignity of the judicial officers serving in such courts and also of the lawyers practicing in these courts. Because you are serving in the trial courts, because you are practicing in the trial courts, does not make you inferior in status and standing. In fact, I would say that a lawyer who does not practice before the trial courts is incompetent. It is as much important to know the procedural law as it is important to know the substantive law. Trial court advocacy will lay a strong foundation for a sound legal practice and beyond. In 2019, I was transferred to the Bombay High Court. And in 2020, unfortunately, the COVID epidemic broke out. All of us were confined to homes, our homes for a couple of months. It was during that period, one student ambassador representing SCC online, she wanted an interaction with me. Judges should not give interviews I firmly believe in that. But there have been aberrations, that's okay, that's a different issue. But I agree to this interaction because it was primarily SCC, it's a law journal. And we have nothing to do during that particular period. So one of the questions the student ambassador asked me in the course of the interaction, "Sir, do you have any regrets in life?" I told her, I have no regrets in life. God has been very kind to me. I have this far. However, insofar my professional career as a lawyer is concerned, if I am given an opportunity to rewind my career, in earlier days, we used to have tape recorders, we used to have fast forward and rewind also. Our favorite songs, we used to keep on rewinding and we used to hear and rehear those songs. So I said, if I am given an opportunity to rewind my professional life as a lawyer, I would have devoted more time to trial courts than trial court advocacy. This is one area where I feel I could have done more. And the lacuna still haunts me. Sometimes I feel a little bit I have to go back to the civil procedure code and the judgments. While I am on trial court and trial court advocacy, mind you, Justice H.R. Khanna, one of India's tallest judges ever, he practiced entirely before the Amritsar district courts. Throughout his lawyering days, he was in Amritsar district courts. From there, he was selected to the Judicial Service Grade 1 lateral entry, like many of you. And in 1962, he was elevated as a judge of the Punjab High Court. And in 1966, when Delhi High Court was established and options were taken, out of Punjab High Court, Delhi High Court was taken, options were taken, he opted for Delhi High Court, he became a judge of Delhi High Court. Sorry, in 1966, he opted for Delhi High Court, where he became the Chief Justice. And in 1971, he was appointed as a judge of the Supreme Court of India. And the rest, they say, is history. Why I am saying this? Khanna did not go to any public school. He did not attend any fancy school. He did not practice before the High Court. He did not join any high-profile chambers. He did not practice in the Supreme Court. From trial courts, where he had his roots, he rose to Himalayan heights. Judges will come, judges will go. Chief Justices will come, Chief Justices will go. But we remember only a handful of judges. And in the handful of judges, right at the top, we will always remember Justice H.R. Khanna. Why? I will say a bit later. Friends, it is the trial courts and the district judiciary where the bulk of India's litigation is fought. In fact, 95% of the litigation are fought in the trial courts only. For the litigants, and by extension the general public, trial courts and district courts are the face of Indian judiciary, India's judiciary. This is the face of Indian judiciary. Ahmednagar court, that's all. Very few will can travel to Bombay High Court, very few can go to the Supreme Court. It is the first and in most cases the last point of contact with the judiciary by a common man. Litigants are the main stakeholders of our justice delivery system. Most litigants approach the court as the last resort after suffering great distress. Therefore, my earnest appeal to all of you is that, and that includes me also, our judicial system must therefore be responsive to the cry for justice of this harassed litigants, so as to sustain the fate of the common man in the judiciary. I am tempted to say many things, but I will restrain myself, because as judges, whether we speak in public fora or in the judgments also, or in the court, we need to exercise restraint. It is the bounden duty, I feel, it is the bounden duty of the lawyers and the judges to treat the litigants with respect and with a degree of compassion. Every litigant has a right to know within how much time my case will be decided. He has not come here for some enjoyment or for some charity. He has filed a case after going through so much of pain and harassment. So he has a right to know within how much time my case will be decided. The answer need not be with any mathematical precision, 3 years, 4 years, 5 years, no. But the litigant must feel assured that his or her case will be decided within a reasonable period. At least this much the system owes to a litigant. According to me, if a case is pending at any stage of our hierarchy, judicial hierarchy, for more than 5-6 years, then it is a matter of concern and it certainly calls for introspection. The National Data Judicial Week, as on 26/8/2025, shows total case pendency in Ahmednagar district as 2,27,959, out of which 84,000 odd are civil cases and 1 lakh for the availability of counsel. So friends, this reason is citing about 30,000 odd cases. So this is also one reason we should ponder about adjournment. Sometimes it's necessary. For genuine reasons it is necessary. But please try to avoid adjournments. Bombay High Court has a culture not to seek adjournments, because lawyers are always ready to argue their cases. Justice Rohit has already said many things about my young lawyer friends. I will not repeat what he has said. But just as the adage goes that Rome was not built in a day, a legal profession cannot be built overnight. It requires hard work, sincerity, and perseverance. I don't like the expression, but this expression beautifully sums up the legal profession. And this expression says, law is a jealous mistress. So, law is a jealous mistress. In fact, Supreme Court has taken out a book, written a book, a handbook of expressions which are to be avoided in court proceedings. I think mistress is also a word which is to be avoided in court proceedings. So is the word concubine, which you will find not in the earlier judgments. This expression used to find place. But this expression says that law needs complete commitment. It is not rocket science. Law is not rocket science. It is not nuclear physics. Everything is there in the book. All that you need is to study is equally applicable to the judicial officers also. All that you need to do is to read and read and read. The fire of the books, the more you read a judgment, the more you read a section, you give a different perspective. What is right, what is wrong, it is always an evolving process. We are here not to decide or judge what is right, what is wrong. We are here to decide what is legally permissible, what is not legally permissible. Our morality may say something else, but we are not bound by the morality. Rohit has said about majoritarianism has to adhere to the principles of the Constitution. It cannot decide cases on the basis of majority opinion. Even if one person says one view of one person is correct, and that is as per the Constitution and the laws, that view has to be upheld. It is not anti-majoritarian in that sense. In that sense, it is contra-majoritarian, a view which is to be followed by the courts, irrespective of the views taken by the majority of the people. Legal practice is not 2020 cricket. Nowadays, it's all 2020 cricket. But law practice, as I said in one meeting in Pune, where I was addressing the bar, it is not 2020 cricket. It is not even one-day cricket. You must have the tenacity and the technique to play a long innings like a test cricket. We should be able to handle the spinners, and we should be able to handle the bouncers also. Because sports are going to throw bouncers at you. There is no shortcut to success. It's not a bed of roses. But if you are successful, and if you are sincere, success is bound to come. The sky is the limit. Please read the autobiography of Fadi Nariman, the doyen of the Indian bar, punishments by the agricultural teacher. So he said, the bar is a school of hard knocks, where you learn your advocacy. I would say that the bar is a great institution. It's a great institution. I am a product of the bar. It's a great institution. All of us are products of the bar. It's a great laboratory. In the bar, you could not say he comes from this background, he comes from that background. We are all equal in the bar. And the spirit of the bar reflects the spirit of democracy. Each bar, and that includes Ahmednagar bar also, has developed healthy traditions over the years, conventions and traditions, which are handed down by one generation of lawyers, as you have learned it from your seniors. You will hand it down to the new generation of lawyers. And this is how the practice of law not only survives but also gathers strength. Wherever I go, I said, William Shakespeare had said about the lawyer, eat and drink as friends do in law. Strive mightily, but eat and drink as friends do in law. Inside the courtroom, you are fierce competitors. You will not yield an inch. But the moment you step out of the courtroom, your colleagues, your friends. That is the essence of the legal code. That is the nobility of the legal code. In Mumbai, when the SCC online, and its capacity to resist political pressure. I said, I can't speak for others, but I can speak for myself. I have never faced political pressure or interference. A free and fair and independent judiciary has evolved in India, built literally brick by brick by great men and women, both at the bar and the bench. There are aberrations. There are bound to be aberrations. We have 34 Supreme Court judges. We have 1,000 plus High Court judges. We have 15,000 plus trial court judges. Aberrations are bound to be here. But that does not define the judiciary. It should be our collective endeavor, me, you, everyone, the bar and the bench, to ensure that judiciary continues to remain independent in India. Independence of judiciary is so vital and important for the functioning of this country, the great country of ours, as a democratic republic. So, to highlight this point, I will just give instances of 2 judges and 1 lawyer. Next time when I come, I will give another 2, this time 2 lawyers and 1 judge. So this time I will give about 2 judges and 1 lawyer. 1 judge prior to independence, 1 judge immediately after independence. In 1941, Justice Radha Vinod Pal was appointed as a judge of Calcutta High Court. Like Bombay High Court, Calcutta High Court is also a chartered Madras High Court. Later on, he did not get a chance to become Chief Justice of the Supreme Court, but he was appointed as a judge in the International Military Tribunal for the Far East to conduct war crimes post World War II, committed during World War II in the Far East by Japan, Japan's military leaders and political leaders. Like in Europe, we had the Nuremberg trials where the German leaders were prosecuted. In Japan, you had the Tokyo trials. And one of the judges was Justice Radha Vinod Pal. Justice Pal will be remembered. History has remembered him, and he will be remembered for his powerful dissent, running into 1230 pages, which went far beyond disagreement. Justice Pal said, this prosecution of Japanese leaders and generals is fundamentally wrong because this charter that the Allied powers have created constituted crimes, made certain conduct crimes which were not crimes when those were committed. We have Article 20, Sub-Article 1. To be a crime, it must be a crime when the act was committed. You can't post facto create a crime and prosecute a person. This is the point that he highlighted. And he said this Tokyo trial suffered from this very basic element. He will be remembered for his dissent, courageous dissent. He did not waver, but underscored a timeless truth that the rule of law must prevail over political expediency and must triumph even in the face of the gravest of conflicts, be it domestic or international. The judge must be able to stand still, erect, even in the face of strong political winds of the time. It should not be seen to win. That's the moral from Justice Radha Vinod. The second instant trial deed was immediately in the 50s after the Constitution had come into force. One more thing, the people of Japan have remembered Justice Pai. Many of us, we don't remember him, we have forgotten him. Many of us will not have even heard of him. But the people of Japan has remembered him. There is a book written about him called Hirohito and the Making of Modern Japan. There is also a memorial at Tokyo. Those who have gone to Tokyo have not been. Those who have visited Tokyo, there is a place called Yasukuni Square. There is a monument built to honor the legacy of Justice Pai. Now coming back to the 50s, post-Constitution, post-independence, Patanjali Shastri was the Chief Justice of India at that point of time. And the next senior most judge was Justice Mahajan, Meher Chand Mahajan. The second in line was Justice Bijon Kumar Mukherjee. One day, the Prime Minister, the then Prime Minister, called on Justice Mukherjee and told him that after Shastri retires, the government is thinking of making you the Chief Justice of India by superseding Justice Mahajan, who was senior to him. On the retirement of Justice Patanjali Shastri as the Chief Justice of India in January 1954. In the course of that interaction, this is written in that book by Nariman, Before Memory Fades, you will find it. In the course of that conversation, the Prime Minister mentions about Justice Mahajan and said that the government has reservations, both were from Kashmir. So therefore he gave the notice. Now that's not very relevant for us. What is relevant is the response of Justice Mukherjee. Justice Mukherjee told the Prime Minister that if the seniority norm is violated, if the seniority norm is not followed, and instead of me, or instead of Justice Mahajan, I am with the Chief Justice of India, I will tender my resignation. These are great men who have contributed to the making of Indian judiciary. We are carrying forward that great legacy, that great heritage. Even if we cannot add to it, let us not do anything which destroys or hurts the credibility of the institution, because of which we are all standing here, because of which we have our standing in society. Now let me talk about a lawyer. He is also from this state. in one case after the other. First case was, let us say, the case of Goloknath. You may have heard about it. In 1967. This is about the land laws and the Article 368, the power of amending the Constitution. Goloknath was represented by Nani Patri. Till Goloknath, the view taken by the Supreme Court was that Article 368 gave complete power to the Parliament to amend the Constitution. Any provision of the Constitution could be amended. But in 1967, Goloknath came as some kind of reverse this and said that because of its very nature, fundamental rights in Part 3 of the Constitution cannot be amended. That power cannot be traced to Article 368 by the power. This is a view in Goloknath. This is 1967. In 1970, 14 nationalized banks were 14 private banks were nationalized. And this was challenged before the Supreme Court. This famous case, this case was also petitioners were represented by Parliament. 71, the third case, that is the primary purse case. See, in 1947, when the priestly states, they were given an offer. Either you join Indian Union or we take it by force. If you join Indian Union, you will be given some financial benefits which were known as privy purse. During that period, the central government took a decision to abolish private purse. This Jyotirgaditya Scindia's father, the present Union Minister's father, Madhav Rao Scindia, he filed a writ petition in the Supreme Court. And he was represented by Nani Patri. And he successfully obtained orders from the Supreme Court. So this, one after the other, there are many cases, these three cases. Goloknath, the bank nationalization case, and the private purse case. These are all argued by Nani Patri. But his best was yet to come. It was in that famous case of Keshavananda Bharat versus State of Kerala that Palkiwala was seen at this place. The hearing went on for 6 months. He used to come from Bombay, argue and do. Ultimately, there was a tie. Initially, there was a tie, and Justice Khanna, who treated the balance. 7:6, the majority held that Article 368 of the Constitution gives ample powers to the Parliament to amend the Constitution, including fundamental rights. But they put in a caveat. But this power of amendment cannot be so exercised so as to destroy the basic structure. The government of the day should have been happy because the review was upheld. by the Supreme Court, but they were not happy with this basic structure. Even today, there are many influential people who would question the legitimacy of this doctrine. But I would disagree that this is a 13-judge bench judgment of the Supreme Court. And as long now, because the government was unhappy, there was an attempt to review this judgment. And this was in 1973, November 11, 1973. Those who were present there on that afternoon in the Supreme Court, including Justice Khanna, who was on the bench, and Mr. Endeavour, who was earlier Advocate General of Maharashtra, then Solicitor General, who represented the state of Kerala in this case. They have written. H.R. Khanna, in his autobiography, Neither Roses Nor Thorns, and Endeavour in his book, An Inside View of the Struggle for Supremacy between the Supreme Court and the Parliament, that the kind of advocacy displayed by Palkiwal was never seen before in the Supreme Court and perhaps would never be seen in the annals of the history of the Supreme Court. At all times, he was a great orator, a great lawyer. But that afternoon, he argued as if he was a man possessed. So impactful was his argument about the effect of diluting the Keshavananda Bharati judgment by taking away this basic structure doctrine. That the bench, they said that we can't. And the next day, the Chief Justice of India dissolved that bench. So that abortive attempt to review Keshavananda still ended. Subsequent judgments, there are more than 10 Constitution bench judgments upholding this doctrine. Through these judgments, democracy and independence of the judiciary have been held to be basic features of the Constitution. Independence of the judiciary and democracy are intertwined, linked. If democracy has to survive, judiciary must remain independent. If judiciary has to remain independent, there must be a strong and a vibrant bar. There an uncompromising bar. As I said, judges will go, judges will come and go. But institutions like the bar will remain. And the bar must face to protect its ways to protect democracy and independence of the judiciary. In one recent function in Pune, organized by the Bar Council of Maharashtra and Bhuyan to felicitate Justice Oak, there were not many speakers, so I had very little time. With the little time at my disposal, I spoke. Justice Mahesh Sonak, referred to John F. Kennedy, the US President. So I said I will not talk about John F. Kennedy, I will talk about John F. Kennedy's daughter, Caroline Kennedy. And I referred to her speech. Caroline Kennedy herself, an eminent author, attorney and a diplomat. She was US Ambassador to Australia. And I quoted her. Caroline Kennedy had said, and it sums up the topic of today's deliberation. The bedrock of our democracy is the rule of law. And that means we have to have an independent judiciary. For an independent judiciary, we must have judges who can take decisions independent of the political winds that are blowing. And I said, if it is true for America, it is more true for India. Today in the morning, the host of the program had referred to my speech in the Maharashtra Judiciary Academy, where I had quoted Justice Frankfurter, to say that judiciary has neither the pulse nor the sword. It has only moral authority. And that moral authority will be eroded if, as Lord Denny used to say, if a litigant goes away from the court saying that he was not heard or that the judge was biased, I would add to this. Justice must not only be done, but must be seen to be done. A judge has not only to be impartial, but must be seen to be impartial. Friends, sociologists say that man is a political animal. A judge is, after all, a human being. It is therefore quite natural that a judge can have a political leaning. There's nothing wrong in it. In America, the Republicans pick up their own judges, Republican judges. When Democrats come, they pick up their own Democratic judges. Democratic judges who were intended to be liberal end up being more conservative. Conservative judges picked up by Republicans intended to be conservative end up being more liberal than the Democrat. Another matter. But our political views that we have should remain government as long as we are on the page. And that should not cloud our decision making. It will be a sad day for all of us, judges, lawyers, and the citizens of this country, if a decision becomes a foregone conclusion the moment it is listed before a particular judge or a particular bench. That could be the end of judicial independence, that could be the end of judicial impartiality, that should be the beginning of the end of the democracy. As I said, as Justice Rohit has said, we are not only a parliamentary democracy, but a constitutional democracy as well. But what do we understand by democracy? Is it about holding periodical elections? Every 5 years we hold elections. Does democracy start and ends here? According to me, democracy is a way of life where issues confronting the society and beyond are discussed and debated, where we have an informed citizenry, where decision making is based on consultation, not always or not necessarily on consensus, but people are heard. We are in the land of Dr. Ambedkar and Mahatma Gandhi. Dr. Ambedkar has had repudiated the caste system. He had rejected the caste system. So he was asked, sir, since you have rejected the caste system, he said, caste system is unscientific. It is based on questionable economic model. It is highly immoral. Then he was asked, since you have repudiated the caste system, what kind of a society you would aspire to? And his answer was, I would aspire for an ideal society which is based on liberty, equality, and fraternity. Dr. Ambedkar explained these concepts of liberty, equality, and fraternity as another name for democracy. Democracy is not merely a form of government. It is essentially an attitude of respect and reverence towards our fellow human beings. And that is, we all do at the bar. And this is what we do in the courts. When a lawyer argues, judge hears, the judge will hear the other side and they will take a decision. And this is what this democracy is all about. In 1967, one case went from Bombay to the Supreme Court. Naresh Sridhar Virajkar. In that case, a 9-judge bench of the Supreme Court held that in India, we have an open court system where people can come and watch the court proceedings. Supreme Court said public trials act as a safeguard against judicial arbitrariness, and it plays a crucial role in enhancing public confidence in the justice delivery system. Open justice is not merely a procedural formality, but a fundamental element of democratic legitimacy. In this recent case of Wikimedia Foundation versus CNI, a bench of Justice Rohit and myself, we have held that the courts should not shy away from constructive criticism, even if a matter is sub judice before the court. Friends, our constitution has stood the test of time. 75 years strong, like many of you, and still growing. It has stood the test of time. It has transformed. It's a transformative document. It has transformed a highly feudal society practicing graded inequality into a forward-looking society. It has been outside of the mainstream, on the margins, into the mainstream, and given them dignity and status. It has given voice to the voiceless. But it is still a work in progress. It is our collective heritage, our constitution and the jurisprudence that we have developed is our collective heritage. The Supreme Court must remain the conscience keeper of the constitution. The rights which have accrued, the rights which we have developed, we cannot allow those rights to be rolled back and go back to the days earlier days. This is not possible. Our constitution, as long as it survives, will not come. Therefore, all of us must be vigilant enough to protect our constitution. Friends, I think I have spoken enough, taken much of your time on a holiday, on a Sunday. But before I conclude, let me go back to my interview, that Mumbai interview one last time. After that, I told her, your success must be built on the edifice of your hard work, talent and merit. Your success must be yours and not at the expense. There is enough space for everybody in the legal profession to shine and to become one. I must profusely thank the Ahmednagar Central Bar Association, its office bearers, all the members of the Ahmednagar Bar for inviting me and my wife to come here to this historic city, this bar association, and giving me an opportunity to share some of my random thoughts. I wish all of you the very best in life. Thank you very much and God bless.
Thanks a lot, sir. Though I am not a law student or a law practitioner, but as a citizen, what I understand from this speech, I just want to share. Maybe it will be wrong, but when you share a Shakespearean quote, I found that nowadays we are keeping ourselves away from it. We must come together and try to understand and try to solve the problems. We are lacking of healthy communication, which is the core element of any democracy, a communication. But today we are communicating with each other, but there is not a healthy communication. Then we are losing the respect of others. In democracy, there is also a core element to respect others, but we are lacking that also. And you told about the politics. As a human being, we cannot keep ourselves away from the politics. But we must keep it personal and not professional, as you quoted in your speech. So, what is democracy then? Democracy should become a way of life, and we should accept it according to the time and what is going around us. That's what I understood as a citizen. It might be wrong, but I try to find the meaning through your speech. आपका बहुत बहुत आभार व्यक्त करते हैं सर कि आपने बहुत अलग-अलग तरीके से इस सब्जेक्ट को हमारे सामने रखने की कोशिश की. आप आपने कहा कि छुट्टी के दिन आपने हमारा बहुत समय लिया, लेकिन सर हमारे ख्याल से आपको तो छुट्टी भी नहीं मिलती है. हमें तो वैसे भी फिलहाल मिल जाती है, लेकिन आज भी आप एक अलग तरीके से यू आर वर्किंग फॉर ऑल ऑफ अस, एंड थैंक्स अ लॉट. आई विश यू ऑल फॉर द बेटर डे. या सगळ्या कार्यक्रमाचा यांचा सन्मान करावा. आणि यानंतर विनंती करतो ऍडव्होकेट योगेशजी काळे सचिव अहमदनगर सेंट्रल ऍडव्होकेट्स बार असोसिएशन यांना की त्यांनी या कार्यक्रमाचं आभार प्रदर्शन करावं. त्यानंतर पसाय दान होईल आणि मग कार्यक्रम संपन्न होईल.
आदरणीय व्यासपीठ व व्यासपीठावर विराजमान सन्माननीय प्रमुख अतिथी, कार्यक्रमाचे अध्यक्ष तसेच उपस्थित सर्व मान्यवर यांना मी प्रथम अभिवादन करतो. कार्यक्रम झाला बहारदार, भाषणे झाली जोरदार, कार्यक्रम झाला बहारदार, भाषणे झाली जोरदार, श्रोत्यांनी उचलला श्रवणाचा भार, तेव्हा मानलेच पाहिजे सर्वांचे आभार, तेव्हा मानलेच पाहिजे सर्वांचे आभार. आजच्या या कार्यक्रमाची व्याख्याते माननीय न्यायमूर्ती पूज्यजी भुयान साहेब, सुप्रीम कोर्ट ऑफ इंडिया यांनी त्यांच्या व्याख्यानातून अतिशय चांगले ज्ञानदान करून अमृततुल्य असे मार्गदर्शन केले. तसेच बारच्या विनंतीला मान देऊन अहमदनगर सेंट्रल ॲडव्होकेट्स बारच्या विनंतीला मान देऊन सत्कारही स्वीकारला. त्याबद्दल मी बारच्या वतीने त्यांचे खूप खूप आभार मानतो. त्यानंतर माननीय न्यायमूर्ती भुयान साहेब यांच्या अर्धांगिनी सौ संगमित्रा दास भुयान मॅडम या देखील कार्यक्रमात उपस्थित राहून सन्मान स्वीकारला. त्याबद्दल त्यांचेही मी मनपूर्वक आभार मानतो. त्यानंतर आजच्या कार्यक्रमाच्या अध्यक्षा माननीय न्यायमूर्ती विभाजी कंकणवाडी मॅडम, उच्च न्यायालय मुंबई खंडपीठ औरंगाबाद यांनी आजच्या कार्यक्रमाचे अध्यक्षस्थान भूषविले. तसेच भाषणामधून आपल्या सर्वांना मार्गदर्शन उपस्थित राहिले, भाषणातून त्यांनी मार्गदर्शनही केले, तसेच यथोचित मान सन्मान स्वीकारला. त्याबद्दल मी त्यांचं बारच्या वतीने आभार मानतो. आमच्या अहमदनगर जिल्ह्याच्या प्रथम महिला प्रधान जिल्हा व सत्र न्यायाधीश म्हणून मान मिळालेल्या, तसेच न्यायालयाचे पवित्र असे काम करत असताना वकिलांच्या अडचणी व प्रश्न सोडविण्यात त्यांचा हातखंडा आहे अशा आमच्या जिल्ह्याच्या प्रधान जिल्हा व सत्र न्यायाधीश मॅडम श्री अंजू शेंडे यांनीही त्यांच्या भाषणातून आपल्याला मौलिक मार्गदर्शन केले. तसेच बारचा सन्मानही स्वीकारला. त्याबद्दल मी त्यांचे बारच्या वतीने हार्दिक आभार मानतो. तसेच मुंबई उच्च न्यायालयात वकिली करणारे ॲडव्होकेट प्रमोदजी जोशी साहेब, ॲडव्होकेट नितीनजी गवारे साहेब, किशोरजी पाटील साहेब वेळावेळ काढून आवर्जून कार्यक्रमास उपस्थित राहिला व बारचा सन्मान स्वीकारला. त्याबद्दल मी यांचे आभार मानतो. त्यानंतर अहमदनगर सेंट्रल ॲडव्होकेट्स बारने एक आगळा उपक्रम केला की बारचे 75 वर्ष पूर्ण झालेल्या ज्येष्ठ विद्यार्थ्यांचा सत्काराचा कार्यक्रम ठेवला. यामध्ये या सत्कार सत्कार स्वीकारला. त्याबद्दल मी त्यांचा बारच्या वतीने हार्दिक असा आभार मानतो. त्यानंतर बारच्या उपस्थित सर्व वकिलांनी कार्यक्रमाला उपस्थिती दर्शवून योगदान दिले, तसेच हाताळून कार्यक्रमाची शोभा वाढविली. त्यांचेही मी बारच्या वतीने आभार मानतो. तसेच आमच्या जिल्ह्याचे जिल्हा सरकारी वकील एस के पाटील साहेब यांनी देखील वेळावेळ काढून कार्यक्रमाला उपस्थिती दर्शवली व कार्यक्रमाची शोभा वाढविली. त्यानंतर सुट्टीचा दिवस असून देखील अहमदनगर येथील न्यायालयातील न्यायिक अधिकारी तसेच जिल्ह्यातील विविध तालुक्यातून आलेले न्यायिक अधिकारी यांनीही उपस्थित राहून कार्यक्रमाची शोभा वाढविली. मी त्यांचेही बारच्या वतीने आभार मानतो. लॉ कॉलेजचे प्राचार्य यांनी देखील कार्यक्रमास उपस्थिती दर्शवली, त्यांचेही आभार मानतो. यानंतर सोमनाथजी घारगे साहेब, जिल्हा पोलीस अधीक्षक यांनीही उपस्थिती दर्शवली. बारचा सन्मान स्वीकारला. तसेच त्यांची टीम देखील त्या ठिकाणी उपस्थित आहे. त्यांच्या सर्वांचे देखील बारच्या वतीने आभार मानतो. यानंतर आनंदजी भंडारी साहेब, मुख्य कार्यकारी अधिकारी अहमदनगर जिल्हा परिषद यांनी देखील या कार्यक्रमास उपस्थित राहून कार्यक्रमाची शोभा वाढवली. त्यांचे मी बारच्या वतीने आभार मानतो. तसंच कुमारी स्वाती फुले मॅडम, आंबेडकर मॅडम व इतर विद्यार्थी समर्थ विद्यालय यांनी स्वागतगीत सादर केले व त्यांना वाद्यवृंदाने साथ दिली. त्यांचे देखील मी आमच्या बारच्या वतीने आभार मानतो. प्रेमनाथजी पुत्रा अध्यक्ष अगदी सुमधुर अशा वाणीने प्रसादजी पेडेकर साहेब यांनी सूत्रसंचालन केलं. त्याबद्दल मी त्यांचा बारच्या वतीने हार्दिक असा आभार मानतो. कार्यक्रमाच्या यशस्वीतेसाठी दिलेल्या योगदानाबद्दल अशोक पाटील यांचे देखील मी आभार मानतो. उपस्थित असलेले सर्व पत्रकार, कोर्टाचा स्टाफ, डेकोरेटर्स, केटर्स, मंडप, साऊंड सिस्टीम, फोटोग्राफर तसेच वेळ पैसा परिश्रम खर्च करून कार्यक्रमाच्या यशस्वीतेसाठी प्रयत्न केले असतो.
आज लाईव्ह प्रसारण सादर करण्यासाठीचे कलाकार आपल्या समोर उपस्थित नाहीये, त्यामुळे आज रेकॉर्डेड प्रसारण आपण लावणार आहोत. धन्यवाद. पुन्हा एकदा सगळ्यांचे मनपूर्वक आभार. काहींची नावं घेण्याचं राहिलं असेल तर त्याबद्दल दिलगिरी व्यक्त करतो आणि मंचावरील सर्व सन्माननीय व्यक्तींच्या परवानगी हा कार्यक्रम